Welcome back. The trial I mentioned earlier didn't end up streaming, but I've got something even more intense instead. Two courtroom incidents from Florida and Washington that quickly spiraled out of control. Let's get into it.
I would have one of those us. I don't seem to have. I hid it for myself and Mr. Gonzalez. You ordered to stay away from 150.
Judge, he's not. I apologize for interrupting. He's no longer there. Corrections took him away.
Okay.
Utilize my right to be heard, and I'm representing myself, Your Honor. I just got back from the last courtroom where I was RR'd. Are you ready to hear what I have to say, Your Honor?
I am.
All right, cool. So, I would like to inform you, Your Honor, that there is two open lawsuits. One against this court system for wrongfully finding probable cause on police misconduct and violating my 6th and 14th Amendment and due process, which led to false imprisonment. Against the Miami Beach Police Department for multiple false arrests where they have violated my constitutional rights and multiple United States laws. This situation is very serious, Your Honor, because I now have to file another lawsuit for attempted murder and attempted vehicle manslaughter. I say vehicle manslaughter because these two police officers that followed and stopped me November 6th is the same two police officers that watched me park my bike on 10th and Ocean, pace back and forth next to my bike on 10th and Ocean, and then hit me off my bike while they ran onto the sidewalk, also hitting two other pedestrians. So that was vehicle manslaughter.
Vehicle manslaughter, you claim? I regret to inform you that manslaughter charges require a very specific legal element, the existence of an actual fatality. And while your decision-making may have been questionable, you are, quite evidently, still present, conscious, and fully capable of standing trial.
They never tried to attempt to pull me over. Like the A foreman said, they tried to, that I tried to evade them. They tried to pull me over. Because if I tried to run away, why did I park my bike? And you see me park my bike on 10th Street. So look, let me continue. There's another one that I have to file for attempted murder because when they said, put your hands behind your back, they kept me, they prevented my hands from going behind my back while covering my face and mouth. That is attempted murder. So now let me start. November 6th, right? And I've had this bike since February. November 6th, these officers witnessed me talking to three girls or whatever. They followed me for 3 blocks and then took the same right turn that I took. And then I made a U-turn onto the sidewalk and then they stopped following me. Then they approached me when I was talking to my friend on a bike lane on Ocean Drive between 11th and 10th Street. That is when they wrote the ticket. And they said, if I don't walk my bike home, my electrical bicycle, then I'll be arrested. So I walked my bike home and then went back to the same officer, Officer Rivera, after I did my research. And I told him that because my bicycle has pedals, it is considered an electrical bicycle. So if you try to arrest me for riding my electrical bicycle, I will file another lawsuit against you. And then I rode my bicycle November 6th and no one said anything. I rode my bicycle November 7th. No one said anything. I've had this bike since February 8th. I've got pulled over for running a red light. I even called the sergeant. The regular officer and the sergeant never said my bike was not street legal. This was March. This was July where I got pulled over again. I requested the sergeant, the regular sergeant, and the regular officer and the sergeant never said that my bike was not street legal at all. So what I'm saying is, to you have a judicial code of conduct. You have to follow the law at all times. It's your duty to follow the law. And based on the 14th Amendment, I have the right to be treated equally. So if they're not arresting DoorDash drivers, Uber Eats drivers for riding their electrical bicycle, you cannot keep me in jail for riding my electrical bicycle. This is what I explained to the judge previously, and I got RR'd. And the public defender had did their research. They found out that with pedals, it's still considered an electrical bicycle. And I even informed this officer, and he even seen me riding southbound. He made eye contact with me on November 8th on Saturday. He made eye contact with me while I was driving southbound on Ocean Drive. If I was riding something illegal, right? If I didn't go back up to him and tell him that if he tries to arrest me for riding my electrical bicycle, he will be sued. Why didn't he just pull me over? If what he said that happened on 9th Street, why didn't he pull me over? Why didn't he pull on his golf cart and pull me over? He did no such thing because that is a lie. He lied on the A form, and I'm proving it to you because I parked my bike down this 1 block away. So if I really tried to run away from the police, why did I park my bike 1 block away? And based on the fruit of the poisonous tree doctrine, anything that rooted from illegal activity cannot be used against me in the court of law.
Your understanding of Wong Sun versus United States and the fruit of the poisonous tree doctrine is not entirely accurate. In general, the rule allows certain evidence to be excluded if it was directly obtained through unlawful police conduct, but it does not automatically invalidate an entire case or guarantee dismissal. Any suppression motion still depends on showing a clear connection between the alleged illegality and the evidence being challenged. At the same time, your version of events is not consistent, which creates a credibility issue that would need to be resolved before any legal argument under this doctrine could be properly evaluated.
All the charges has to be dismissed. From riding with a suspended license, I don't need a license to ride my electrical bicycle. Vehicle registration, I do not have to register my electrical bicycle. And driving with a license suspended, I don't need to have a valid driver's license to ride my electrical bicycle. And this all...
Judge, on his traffic case, he received RR.
Well, good. Anyway.
Yes, so what I'd like to say is that also Burger King is across the street from the police department, so no police officer can say that they don't see other electrical bicycles and other dirt bikes riding on the beach. So it's no excuse, not even just pouring it out that they lied on an A form. And it's all my workers. I even have a video. There was electrical bicycles passing by November 6th as they was writing me a ticket for my electrical bicycle, which was a blatant violation of my 14th Amendment. So they continue to write a ticket for my electrical bicycle as someone pulled over and said, "What's going on?" A restaurant worker that usually parks their electrical bicycle right there on Ocean Drive. You cannot be a police officer and say you don't see electrical dirt bikes riding on Ocean Drive and electrical bicycles riding on Ocean Drive, because there's 15-year-olds with electrical dirt bikes since last year that has been riding up and down Ocean Drive, and no one has said anything to them. So it would be a blatant violation to arrest me or harass me for riding my bike. So I would like to be involved with this as well, because I'm not sure why it was divided into 2 judges at all. And the public defender already looked at the law. If you want to look at the law, based on the fact that my bike has pedals, is considered an electrical bicycle.
All right then. So it sounds to me like you already raised a mystery, Judge, about your pedals and your electric bicycle. I myself am dealing with 4 counts of battery on a law enforcement officer, 1 count of resisting an officer without offering to do violence, 1 count of felony marijuana possession, and 1 misdemeanor arresting. So those are the cases I'm dealing with.
Yeah.
Not that whether or not your bike has pedals on it.
I'd like to include, Your Honor, that my older brother passed away because someone hit him off his motorcycle 2016. I would never run away from the police. And the fact that they waited till I hopped on my bike to try to hit me, to try to build a false narrative like I was evading them, is completely illegal. They waited till I hopped back on my bike after seeing me hop off my bike. So that is what?
You are, by all appearances, still alive and fully capable of participating in these proceedings, which makes the suggestion of manslaughter legally unsupportable on its face. As for the matter at hand, the court will now hear from the judge, who is prepared to address the situation directly and provide a clear ruling based on the facts presented.
So now I have to file another...
It would only be vehicle manslaughter if you were dead, but you are quite chatty for a dead person, so I really can't find that you're dead.
Why did they attempt to murder me? They covered...
well, that's a horse of a different color. So what I have to deal with was what's written on the arrest affidavit, not your constitutional arguments, which may very well be filed in a different court on a different day. I have to deal with the 4 corners of the document there.
Yes, based on the 4 corners of it.
Based on the 4 corners of the document, I'm going to find probable cause on counts 1, 2, 3, 4, 5, 6. And let me ask corrections. Was the resisting without violence dealt with in misdemeanor court or not? Well, that's
I would like to speak, Your Honor. If
Stop! I'm trying to get an answer from corrections as to whether or not the resisting without violence was managed misdemeanor court or not.
Your Honor, if I have to pay any type of bond, then I will file another lawsuit against this court system.
Well, alrighty then. Please feel free to do so. Probable cause is found on counts 1, 2, 3,
And the fruit of the poisonous tree doctrine that rooted from illegal activity, it cannot be used against me in a court of law.
yes, it's
Understand that
the constitutional background for a motion to suppress evidence that was seized. I read that case once. So counts 1 through 4, the bond is $2,000. Count 5, the bond is just $1,000. Count 6, the bond is $1,000. Count 7 is an ROR.
Judge Victoria Singular,
I am Judge Victoria Sigler.
not RR.
All right.
I will file a tort.
Please feel free to file whatever things you think are appropriate.
It is not uncommon for defendants to believe that threatening legal action against the court will improve their position, but in practice it rarely has any beneficial effect and can further complicate their situation. We now turn to proceedings in Washington State, specifically Bellingham County, where the next individual before the court presents an equally disruptive set of circumstances.
This is case number 5A08688584. I did review the report that was completed and filed by DSHS. And does the city want to be heard at all?
City would ask the court to adopt DSHS's recommendations or findings.
Does defense want to be heard at all?
Yes.
Your Honor, we also ask the court to enter this finding, and we also ask the court to withdraw the assigned attorney due to breakdown of attorney-client relationship.
Yeah. And I would like to be heard on the record as well.
The court does adopt the report that was filed by
does the report
DSHS
say?
finding competency in this case.
Is it uncomfortable? Okay, cool. Sweet.
That was by Western, right?
Yes, sir.
I'll check that box.
So now can I go through a full phoretic colloquy so that then I represent myself and you are no longer... Okay.
We're not going to do that today, though.
Well, I'd like to do that because I'd like to, not have the public defenders involved anymore in obstructing, my rights. And then two, I need...
Seems certain to the court that you need legal representation, so I'm not going to do that motion today.
No, I don't, because can you answer this for me? I did a motion to revise the original anti-harassment protection order.
Yeah, that's
and four or five different judges recused themselves on that. Are you aware of that motion to revise?
That's not before the court here today.
No, but it's really relevant, right? Because there's no probable cause to arrest me and hold me for this charge.
Found Mr. Spidell, so.
Then, it hasn't been presented to me. I haven't seen any probable cause affidavit or anything like that. And if you read the motion to revise the original anti-harassment protection order, you see that there was no evidence in that hearing of harassment. All I did was try to let the prosecutor's office know of Brady Giglio material committed by Crystal Chapel, right? Can you let me speak, please?
You're being recorded.
Yes, I want this to be recorded.
You're being recorded and you're making admissions that might be against your personal interest in this case.
No, that's not true because I'm 100. I want the truth to be known. I have nothing to hide. Okay, so.
And we are.
So you guys are obstructing, though. You guys are doing the obstruction here. Okay. So I want this to be heard on the record.
Yeah.
That I've just reached out to the prosecutor's office to let them know about Brady Giglio material committed by Crystal Chapel, and I was concerned that maybe she would be involved in high-profile cases like the cop that I heard was killed, and I would hate to see anything overturned once this comes down the pipe.
You would likely be frustrated if a conviction were questioned due to alleged Brady versus Maryland issues, which relate to evidence disclosure by the prosecution. However, repeating that point does not determine guilt or innocence. A protection order violation is generally decided based on clear evidence presented in court, not assumptions or interpretation.
Focus in on your case and not using.
No, yeah, this is my case, right? I've been sitting here in jail for 60 days without probable cause.
Probable cause is already determined, sir, so you are not sitting.
It's not a smiling matter. No, then tell me what the probable cause was.
Heard in this case.
City would ask to set for trial, Your Honor.
We're setting the matter for trial.
Okay. Then, ma'am, I think that you're outstepping your bounds and you're obstructing justice here. Because if you read that motion to revise the protection order, why have 4 different judges recuse themselves? Why did the gentleman just before you just recuse himself? Everybody's playing hot potato with accountability, but you're the only one who seems that.
And I'm not recusing.
You want to break the law.
Here I am.
Right, but you're not hearing me.
Oh, I am hearing you, sir. And what you're saying doesn't fit with the facts of the case. There was probably.
So what are the facts?
And we're moving forward with trial. You'll get your trial on the merits, sir.
Okay, but I know that you guys are just going to dismiss it before trial happens because you don't want a jury to hear about all your misconduct.
Well, I don't mind the jury hearing what you perceive as misconduct. If it's
okay.
Anyway.
All right, then I'm looking forward to that.
If you let us have a moment, we'll set your trial date.
From my calculations, Mr. Speedle has been in. We have Speedy running from November 5th to December 8th when the order was entered for competency, and so after the competency was on today, we're running from. So it's 33 days. We're 33 days into speedy trial. So I believe if we set by January 27th, 2026, we would be within the 60 days.
Okay.
So
no, that's not true because I was arrested on October 28th.
Let's see about officer.
Today's day 59 or day 65, depending on how you look at it.
20th, we don't have a jury because of the holiday, and that complicates getting a jury. And the 13th is heard by a protest. If it's set on the 13th. So we have the 6th and the 27th, which is pretty close to. The 27th you said is within speedy, so.
I believe so. I'm going by what the jail records say of 11/3 as the booking date.
Okay.
Well, I object, you guys. Didn't you guys swear oaths to uphold the Constitution? Aren't you supposed to protect my rights and not violate them? Why don't I get a speedy trial?
Certainly trying to protect your rights, sir.
Well, then why are you even taking me to trial without probable cause? That's malicious prosecution.
I can't keep answering the same issue about probable cause. It's already been determined.
Well, then can you read to me, for the record, what the probable cause is? Because all in my records, I just see it says warrant, and warrant is not probable cause.
And probable cause is determined before a warrant is issued in this court.
So explain to me then what the probable cause is, why I've been sitting in jail.
And if you would work with your attorney, you would have all of.
That is not how self-representation works in court. You are not acting as your own attorney in this setting. The attorney standing beside you is your legal counsel and remains so unless the court formally permits withdrawal or grants you the right to proceed pro se. Until then, all legal arguments must come through counsel and within the court's procedural rules.
Tell me what the probable cause is for my arrest.
Granted any motion where you're representing yourself, sir.
Okay, well, I don't understand how you can sleep at night with this kind of misconduct. I mean, like, all your colleagues have passed the buck around, playing hot potato, recusing themselves. And you can't even tell me what the probable cause is. You just say that it's already been established. Well, that doesn't fly.
January 27th, 9 o'clock is your jury trial. Status. Do we set status on the Friday? On the Monday. Your status.
You're obviously not a Christian or a follower of Jesus Christ. I can tell that. And you're going to have to answer for this someday, ma'am. You will be judged.
January 26th at 8:30 in the morning for status. Readiness. January 12th, 8:30.
And what about you, Mr. Good? Where's my probable cause? Where's my discovery?
On the same dates.
Correct.
All right, out of custody dates for those matters are the same, only at 1:30. I'll put a note in here for that.
Yeah, put that note in there.
Now, obviously, the court wants Mr. Spidel to be represented through a jury trial.
No. I'm gonna represent myself.
Only if the court allows it.
Okay, well that's not fair, and that's against my constitutional rights. Okay.
Well within.
Yeah, you're holding me without probable cause, and then you're forcing me to have a public pretender who's not gonna uphold my rights, or is actually actively working against me.
Perhaps.
I'm sure.
If you're not willing to work with your current attorney, we can find a conflict counsel to assist you.
I want a speedy trial. I want to represent myself, and I want it today. Today is day 65 of my incarceration without probable cause. That's malicious prosecution, according to RCW 9.62.100.
But I can go through the colloquy, but we can have standby counsel at the very least.
No, well, yeah, I'll do standby counsel, but I want the phoretic colloquy, so I'm representing myself, so that then I can contact the prosecutor directly from the jail. I can get my discovery and everything like that.
It would be, I think, against his personal benefit to be
This isn't a joke, ma'am. Why are you laughing?
legal representation. You know, to present yourself in front of a jury the way you're presenting yourself in court would not be to your benefit.
I beg to differ. I beg to differ.
You are not a practicing attorney handling multiple cases, and that distinction matters in how the court evaluates representation and procedure. Attempting to modify a protection order without following proper legal channels does not override court authority or establish process. Any such request must be handled through the appropriate filings and, where applicable, through counsel, rather than unilateral action or assumptions about procedure.
Sure you do. So, if we do go to trial on January 27th, which it's set for, I would encourage you to, at the very least, have standby counsel to assist you.
Okay. Yes.
So we'll try and find conflict counsel and in short order so that you can speak with an attorney about your jury trial, which is coming up now.
Okay, but in the meantime, I would like Mr. Good to provide me with my discovery and the probable cause affidavit, and also a copy of my motion to revise the original anti-harassment protection order.
That's not for this court. That's a different court.
Ma'am, this is a kangaroo court then.
All right.
You should be ashamed of yourself.
Your opinion.
Be that as it may, yep.
The discovery has been provided, and if you would work with your attorney, you would know all.
I am my attorney, ma'am.
You would know all that.
I want to work with the prosecutor because I'm representing myself, okay?
Not at this moment. We are going to find you conflict counsel to assist you with the case.
No, I object. I object to that. I am fully competent enough, just like the 1077 found, right, that I'm competent enough to stand trial by myself.
Being competent to stand trial is different from being allowed to represent yourself. Competency means you can understand the case and assist in your defense, while self-representation requires a separate legal decision by the court. This distinction exists to protect Sixth Amendment rights and ensure proper procedure is followed.
So if we are going to go through that colloquy and allow Mr. Spidel to represent himself with standby counsel, hopefully,
Yes.
I can do that now. So we.
Yes, please.
Yes, sir.
Thank you, God.
Okay, you have the constitutional right to represent yourself if you choose to do so. It must be knowing and voluntary. And I'm going to make clear on the record this colloquy that you wish to waive your right to represent yourself and that you're fully aware of the hazards that you may face and the disadvantages of self-representation. Do you understand that if you cannot afford to pay for an attorney, can only partially pay, that, and you have been deemed eligible at this point, that you can have conflict counsel take over this case with you?
I understand that I can request counsel, but I don't waive any rights, especially my right to a speedy trial, and I wish to represent myself.
The only way we're going to get through this colloquy and help me make a determination that you can represent yourself is if you answer the questions specifically.
Okay, then can you repeat the question?
I can, yes. Do you understand that you have been deemed eligible for a public defender? If you wish to, we can find conflict counsel to assist and take over the case with you.
Yes.
Have you ever studied law?
I have studied law, yes.
Have you ever represented yourself or any other defendant in a criminal action?
Yes, I have represented myself.
And have you ever, or do you know that you're charged at this time with the anti-harassment protection order violation, 2 counts on this case?
Yes.
You understand the charge? Okay. Do you know that if you're found guilty of these charges, that you could be sentenced up to, these are gross, right? 364 days in jail and a $5,000 maximum fine on each count?
Yes.
Do you know that if you represent yourself, you're on your own unless there's standby counsel, and that the court cannot tell you how you should try your case or even advise you on how to try your case?
Yes.
Do you understand that you have the right to have your guilt or innocence decided by a jury?
Yes.
You understand a jury consists of 6 people chosen from the community?
Yes.
Are you familiar with the rules of evidence?
No.
Do you know that the rules of evidence govern what evidence may or may not be introduced at trial? And if representing yourself, you must abide by these rules of evidence.
Yes.
Are you familiar with the rules of criminal procedure?
No.
These are rules that govern the way in which a criminal action is tried in this court. Do you understand that?
Yes.
And do you know that if you decide to take the witness stand, you must present your testimony by asking questions of yourself, and you cannot just take the stand and tell a story, your story?
Yes.
You understand you must proceed question by question through your testimony if you choose to testify?
Yes.
Why don't you want an attorney to assist?
Because they're not working for me, they're working against me.
Choosing to proceed without qualified counsel for witness examination can be a serious disadvantage, especially in a jury trial where procedure and strategy matter. While self-representation is allowed, the court applies the same rules, and the outcome depends on how the case is handled within those limits.
Have there been any threats or promises that have been made to induce you to waive your right to counsel?
No threats or promises.
Do you realize that if you proceed without an attorney and you do not properly present a defense, subpoena witnesses, or otherwise represent yourself in a competent manner, that you will not be able to obtain a reversal of a conviction on the grounds that you received ineffective representation?
Yes, I'm aware.
All right, then, again, the court would advise that you would be far better served by a trained attorney than you can be by yourself. You've already indicated that you're not familiar with the rules of evidence or criminal procedure. And the court would, again, strongly urge you not to try to represent yourself. But also in light of the penalty that you might suffer if you're found guilty of 2 charges and the difficulties of representing yourself, is it still your desire to represent yourself and give up your right to be represented by a trained attorney?
Yes.
Is this decision entirely voluntary on your part?
Yes.
The court finds that you have knowingly and voluntarily waived your right to counsel, and you are permitted to represent yourself. However, given your lack of knowledge of the rules of evidence and criminal procedure, the court is going to assign standby counsel to assist you in this trial, and would encourage you to work with this counsel so that you can present your case in a proper fashion and according to the rules of evidence and criminal procedure. So we will attempt to find conflict counsel to assist you with the trial. There's a lot involved in preparing. You've indicated that you've represented yourself in the past. I'm not sure which case that would be when I'm looking at your criminal history, but in any case, you've indicated that to the court. So I have factored that into the determination that you can represent yourself. So as soon as we can find conflict counsel, we'll advise them to get in contact with you so they can assist you in the preparation of the case.
Okay, well, in the meantime, all the real assistance I would need is just a copy of the court rules.
Okay.
So if I could get that in, then I could study them, and I wouldn't need any assistance from an attorney at all.
Yes, because clearly a month in custody is more than enough time to master procedural court rules that attorneys spend years studying.
Okay, we will see what we can do about that. Is there anything else from the city's perspective that needs to be placed on the record today?
No, Your Honor.
And counsel or Mr. Spidell, anything else that you'd like to that hasn't already been placed on the record that you would like to have placed on the record today?
Just the fact that I'm still waiting on discovery. So if Mr. Good can please, get that to me in my cell, and also copy of the probable cause affidavit by any deputies working the case. And also I require a copy of my motion to revise the original protection order.
Again, that's not a matter before this court. We don't have jurisdiction on the original order.
No, I'm asking the court.
The one in this court.
I did a motion to revise prior to my arrest.
The other orders are out of different jurisdictions. So that's county.
No, I did a motion to revise the protection order.
Whatcom County Superior. So the only one that we have jurisdiction over is the one that was entered in this court. So if that's what you're referencing, then we can certainly address that at some point. Discovery's already been provided. Did you want previous counsel to provide that to conflict, and
Yes.
it would have to be, reviewed for redaction and such?
Yes, sir.
Okay. All right, we'll get the materials that we can to you and to conflict counsel once we have conflict counsel on board.
Well, in the meantime, I would like it to me, because I don't require conflict counsel, so I don't want that to hold up, me getting my hands on these documents.
We'll see what we can do. The court's closed tomorrow, just so you're aware.
Okay, but did my former attorney here, do they have the discovery and everything? So can't they just provide it to me?
As long as
So long as it's properly redacted, they should be able to provide it.
the previous
Okay.
counsel.
Can you provide that to me?
But counsel, you need to review for any appropriate redaction pursuant to the law.
You understand?
Yeah, I can.
Okay.
All right.
Okay.
Mrs. Spidell, thank you, counsel. Thank you, Mr. Good.
Thank you, ma'am.
And then we're going to switch to official
I'm not
officers. Yeah.
okay.
Oh, this is a set for trial.
Well, I'd need to read it over before I sign it, so.
All you're signing for is the dates there. Signing for the dates there, and also to abide by the previous imposed conditions of release. If bail.
Yeah, I don't agree. I object to the dates, because I want a speedy trial within 60 days. So I'm not going to sign that unless it's under duress.
Just, it's fine. You have notice of the date.
No, it's not fine. So I'm not going to sign anything at this moment. Sorry.
For you not to sign. Counsel, if you want to put in there, refuse to sign, that's fine too.
Yeah.
Okay,
Thank you.
Thank you, man. Have a good day.
Bye, have a great time.
It's been a while since that clip was used, but the point still stands. And as mentioned earlier, it would be useful if the jury trial were streamed, especially since the recent pre-trial readiness hearing wasn't shown. If it does become available, it will be covered. If you enjoyed the video, like it. If not, leave a comment either way, and subscribe with notifications turned on for future updates.